Good day, ladies and gentlemen, welcome back to another What If video. In today's video, I will be discussing the recent Constitutional Court matter of Commercial Stevedoring Agricultural and Allied Workers Union versus Oak Valley Estates. Now, as we know, even if a strike is protected, in some cases, employers are confronted with acts of intimidation and violence. Now, these employers can approach the Labour Court for orders interdicting employees and other persons from committing these actions. The question, however, is against whom is the interdict applied for? In other words, who does the employer say the court must interdict? Is it the union? Is it only those employees who were seen committing acts of intimidation or violence? Or can the interdict be granted against all employees participating in the strike? And this is the question that was considered by the Constitutional Court in the Oak Valley matter. Let's look at the facts. The employer, Oak Valley, was confronted with a protected strike during the course of which acts of violence, intimidation, breaches of picketing rules and other unlawful actions occurred. It launched an application in the Labour Court for an order interdicting these unlawful actions. Important to the case is who was cited as respondents to this case, or in this case. The Oak Valley cited the union, SASAWU, as a respondent. SASAWU, obviously, whose members were on strike, they were cited. Oak Valley also cited 364 Oak Valley employees who had gone on strike and who were referred to as the individual respondents. Oak Valley also cited a group of people referred to as the unidentifiable respondents, and these were described as people who had associated themselves with the employees on strike. Now, the issue in dispute was whether Oak Valley was required to show a link between the unlawful conduct complained of and the individual as well as the unidentifiable respondents. So the court framed the question as the following. Can an employer faced with unlawful conduct committed during a protected strike interdict employees participating in that strike without linking each employee to the unlawful conduct? Now, the Labour Appeal Court, ladies and gentlemen, answered this question in the affirmative. In other words, the court said that it is not necessary to link an employee who participates in a protected strike with the unlawful conduct for the interdict to be granted. But the Constitutional Court rejected this view or this approach, and they argued as follows. One, the purpose of an interdict is to protect an applicant from the unlawful conduct or threatened unlawful conduct. And in the case where final relief is sought, the applicant, in this case Oak Valley, must show that unless an interdict is granted, the respondent, in this case the employees, will continue with its unlawful conduct, or that it is reasonably apprehended that the respondent will commit the unlawful act or acts. But here's the important part. The court said there must be a link or some link between the respondent and the actual or threatened unlawful conduct. Now, ladies and gentlemen, if there must be some link between the respondent and the actual or threatened unlawful conduct, the question is whether the participation in a strike is sufficient to establish such a link. And in response to this question, the Constitutional Court stated the following, that if it is the case that the participation in a strike is enough to create a link between the employee and the unlawful conduct, is it not then inevitable that innocent employees participating in a strike would get caught in the net of an interdict? The court also said that in the view of the Constitutional Court, the Labour Appeal Court's approach did not take into account the prejudice that an employee may suffer. The court said that the interdict could also have a chilling effect on the constitutional right to strike, and it said that if mere participation in a strike carries the risk of being placed under an interdict, it might deter a lawful strike. Therefore, the court concluded that the mere participation in a strike is not enough to establish a link. The court, however, went on to provide some relief or measure of comfort to employers. It stated that the necessary link can be established if it can be shown that the strikers had acted as a cohesive group. The court also said that an employer does not need to lead direct evidence to show that there is such a link. It would be okay or sufficient for the employer to lead indirect or circumstantial evidence where it can be inferred that the employee is or was engaged in unlawful conduct or that the employee associated him or herself with it. The court then embarked on a detailed analysis of the evidence put forward by Oak Valley and came to the conclusion that, save for one employee or one individual and the union itself, no link had been established between the unidentifiable employees and the conduct, as well as the individual respondents listed. So in conclusion, ladies and gentlemen, the effect of this judgment is that an employer cannot seek a final interdict against unnamed or unidentifiable employees during a strike action. Employers must now ensure that they sufficiently link the employees to the unlawful conduct, and an extra effort needs to be made to identify the striking employees. Employers must therefore be able to associate the striking employees with the unlawful conduct. We recommend that employers should keep a record of the strike action from the commencement of the strike, and this can be done by using technology such as cameras and other digital devices to video record and photograph the strike action. In addition, a manager or management or security personnel even should be tasked with keeping a strike diary that records any unlawful conduct, that records the identities of perpetrators and their specific conduct. Now, ladies and gentlemen, that then brings us to the end of this video. Thank you for watching. Should you have any questions on this topic, please leave us a comment below. Until next time, bye-bye.